As already we have finished law of tort and all its chapters, now we'll discuss certain problems relating to law of tort, and almost we have framed 30 problems relating to law of tort which we will solve also. So the first problem relating to law of tort is that an innkeeper owned two inns in the same vicinity. A traveler, a colored man, asked for accommodation at one of them, which was reserved for white only. He was refused, though accommodation was available. He was offered accommodation at the other inn. Is the innkeeper liable? So, the very answer of this problem is similar to those in the case of Constantine versus Imperial Hotels Limited 1944, decided by the King's Bench. In this case, it was held that the innkeeper was in breach of his duty at common law and was liable without proof of actual damage. An innkeeper is bound to take in all travelers if he can accommodate them. If an innkeeper improperly refuses to receive or provide for a guest, he is liable to be indicted and is liable. And the second problem is that the plaintiff, a passenger, was hot on lightning at a station owing to carriages being unsuited to the platform, the station, and the platform belonging to the ex railway by whose clerk the ticket was issued. But the plaintiff had returned by a train belonging to Y company, who had running powers on X company railway line. Discuss X and Y company's liability under the tort law. So the answer to this problem is similar to the facts of the case of GW Railway Company versus Black, which was decided in 1862. So the facts of the case are similar to this above case. GW Railway Company versus Black, which was decided in 1862. So, in this case, the plaintiff, a passenger, was hot on a lightning at a station owing to the carriages being unsuited to the platform, the station, and the platform belonging to the X, which was SW Railways, by whose clerk the plaintiff's return ticket was issued. But he returned by the train belonging to the defendant, Y company, who had running powers on the SW railway line, that was X, it was held that the defendant Y company was liable solely on the ground that it actually received plaintiff as a passenger and thereby undertook the duty of not exposing him to unreasonable peril in any manner incidental to the journey. It was also held that a railway company issuing a ticket, and that is the X company, for a journey partly on the company's own line and partly on the line of another company, may be presumably responsible for the safety of passenger on his whole journey and is liable to compensate him for injuries caused to him by the negligence of the railway servants or defective construction of the carriages or station to whichever company they may belong. Thus, both the companies are liable in the given problem. And now we'll go to problem number 3. And the very problem is that the defendant left his horse and cat unattended in a street. The plaintiff, a 7-year-old child, got upon the cat for fun, incautiously led the horse on, so she was thrown and hurt. Is the defendant liable? And regarding the very answer to the problem, we'll discuss the very leading case, Lynch versus Nuruddin in 1841, decided by the Queen's Bench. So the very facts of the problem have been taken from the case of Lynch versus Nuruddin, 1841, decided by the Queen's Bench. In the case, the defendant negligently left the horse and the cart unattended in the street. The plaintiff, a child, got upon the cart in play. Another child unconsciously led the horse on, and the plaintiff was thereby thrown down and injured. It was held that the defendant was responsible for injuries caused due to the negligence of the defendant by leaving the horse and the cart unattended in a street. So, these three problems that we have solved as under law of tort, so almost we have framed 30 problems. So, in our upcoming video, we will discuss the rest problems, those were incidental to law of tort.